You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We are your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 4, State of Oklahoma versus Richard Eugene Glossip. Today we're going to talk about the Supreme Court's decision vacating Glossip's conviction and remanding his case for a new trial, and the impact of that decision on the Van Treese family. We're also going to look at the evidence of Glossip's guilt that has been ignored by the media and by his advocates over the years. And welcome back, Kyle.
Good afternoon. Good to see you again or hear you again.
I know I don't like doing video. So all right.
I think it was winter last time we talked, and summer, at least in Dallas, has quickly come. So it's gotten quickly warm, like literally overnight.
Mm-hmm. Yeah, it's although this time of year, not necessarily in New Orleans, but a little north, you have that false spring.
That's right. Yes, exactly.
Where, because I've seen it like in New Jersey, New York, Delaware, where they get springy weather in March and then a snowstorm in April.
Well, yeah, as we called it when I was growing up, the Easter snap.
Yeah, the Easter snap. All right, so let's get started. Of course, we start with the victim in this case, Barry Allen Van Treese. He was born December 3rd, 1942 in Kansas City, Missouri. His father was James Braswell J.B. Van Treese, and his mother was Pauline Borden Van Treese. They each, Mrs. Van Treese's mother died in 1996, but his father died in 2016. He had siblings Kenneth, Gary, who died in 1980, and Alana. He also had 2 additional brothers and 1 sister whose names haven't appeared in the media. He was a graduate of Lawton High School in Oklahoma in 1961, Cameron University in 1963. He attended Arkansas State University, and he earned a master's in banking and finance from Southern Methodist University. His occupations were banking, electronics, and motels, which his parents also owned motels, so kind of a family business. He was married to Donna Sue Calloway on March 3rd, 1979. I believe there was a first marriage, but I've never found the identity of that person, so I'm not, intentionally leaving anybody out. I just have never found anything that documents that first marriage. He had 7 children. Barry, Brett, and Barry, I think, was his daughter. Brett, Derek, Ben, Daniel, Bridget, and Joe. He was a member of Lawton Fort Sill Amateur Radio Club and the First Baptist Church, and his causes of death were blunt force trauma and blood loss. The perpetrator in this case is Richard Eugene Glossip. He was born February 9th, 1963 in Galesburg, Illinois. His parents were Heron Glossip and Sally Glossip. He has 9 siblings, I believe. Robert, Kathy, Nancy, Carrie, and 5 additional siblings. He's divorced twice prior to his incarceration. Yes. You okay?
Sorry, just coughing. I was trying.
Oh, I thought you were interjecting something.
No, just a quick coughing fit. Sorry about that.
That's okay. He was divorced twice prior to his incarceration. At the time of Mr. Van Treese's murder, he was engaged to Deanne Wood, who was his living girlfriend. He married Lee Joy Jurassic in 2018. They were divorced in 2021. And he's a piece of crap because he requested spousal support from her. He also used her for money while they were married. And he's currently married to Leah Frederique Roger. They married in 2022. He has 4 children: Christina, Erica Richard Jr., and Tori Lynn. His prior crimes include some driving offenses, juvenile offenses, and uncharged theft and embezzlement charges in this case. And his victim, of course, is Barry Van Treese. I'm not going to really talk about Justin Sneed. He is another perpetrator, but the more egregious of the two of them is Richard Glossip, because but for his desire to see Barry Van Treese dead, Barry Van Treese would have lived probably many more years.
Yeah, so it's because this is one of those cases where Glossip didn't actually physically commit the murder, but planned and got someone to do it for him.
Correct. And, that's another thing that aggravates me. And I've gotten to a point, almost like the West Memphis 3, where I almost am done with this case because it enrages me that they're like, it's a circumstantial case. Well, of course it's a circumstantial case. He didn't have the balls to do it himself.
Well, and you're going to get on one of my pet peeves that I won't spend too much time on is 99% of the people don't have any clue what circumstantial evidence means. And they think that circumstantial means bad. What they don't realize is that 99% of evidence in cases is circumstantial because direct evidence is very narrow.
I think too that another thing is that a lot of people, and I've seen, TV talking head attorneys and detectives who have complained about this. And I'm like, but you're one of the assholes that's up there saying circumstantial evidence is inferior and not worthy of belief.
Right. And the reality is, I mean, from most studies, we find, okay, video evidence is different, but unless you because really, without too big of a rabbit hole, you're basically direct evidence is eyewitness testimony, a confession, or video evidence. Obviously, now the same people that'll gripe about circumstantial evidence will say, oh, well, all confessions are coerced. And then we know that, eyewitness testimony is notoriously unreliable. People can witness something, but they don't always do a great job of describing what they, people regularly has been shown, mistake car colors, even my wife and I argue about what's the color of a car. Is it gray or is it brown? Two people can see two very different things.
Gotcha. Yeah, you're totally on board with that. All right, so the crime occurred on January 7th, 1997. The victim was Barry Van Treese. It occurred at 301 South Council Road in Oklahoma City, Oklahoma, and that is in Oklahoma County. Now, I've done a narrative summary of the crime, but instead, for this purpose, I want to go through kind of like a day-by-day chronological summary of the case, including the crime. So we're going to start. On January 6, 1997, motel owner Barry Allen Van Treese and his wife discover a $6,101.92 shortfall at the Best Budget Inn in Oklahoma City, managed by Richard Glossip. Van Treese tells his wife he intends to ask Glossip about the discrepancy. January 7th, 1997, Van Treese is found beaten to death in room 102 at the Oklahoma City motel, where he was staying while delivering paychecks to employees and picking up money for deposit from motels he owned across the state. On January 8, 1997, Glossip is released from custody after initial questioning by detectives. And at this time, Justin Sneed is in the wind. But detectives know Glossip is involved somehow. They just don't know quite how. And they don't have PC to arrest him on the spot at that time. So he's released. January 9th, 1997, he is arrested while Glossip is arrested while carrying $1,200 days after being paid only $429.33. Investigators say Glossip began selling his belongings and telling people he was leaving town after being questioned by police. January 14, 1997, motel maintenance man Justin Sneed, who was found with $1,700 after Van Treese's death, is also arrested in connection to the death. Sneed later agrees to testify against Glossip. June 1998, during Glossip's trial, Sneed tells an Oklahoma County jury that Glossip feared for his job and promised Sneed $10,000 if he would rob and kill Van Treese. Jurors convict Glossip and sentence him to death. Sneed is sentenced to life without parole after entering a guilty plea. June 10th, 1998, Glossip is convicted of murder in the first degree. June 11th, 1998, Glossip is sentenced to death. January 17, 2001, the Oklahoma Court of Criminal Appeals overturns Glossip's conviction, saying evidence to support Sneed's testimony was extremely weak. Glossip's lawyer was ineffective, and jurors appeared to have consulted a Bible during deliberations, contrary to proper court procedures. June 9, 2004, a second Oklahoma County jury convicts Glossip and sentences him to death. April 13, 2007, the Oklahoma Court of Criminal Appeals affirms Glossip's conviction and sentence. July 1st, 2022, Glossip's execution is set by the Oklahoma Court of Criminal Appeals for September 22nd, 2022. Now, he's had other execution dates prior to that. I'm getting really tired, too, of all these stories. He's had 9 execution dates. Boo-hoo-hoo, none of them ever went forward. He's still alive. Let's stop beating that dead horse. August 16, 2022, Governor Stitt issues a 60-day stay of execution and resets Glossip's execution for December 8, 2022. November 2nd, 2022, Stitt issues a second stay of execution and resets Glossip's execution for February 16, 2023. On January 24, 2023, at the request of the Attorney General, the Oklahoma Court of Criminal Appeals resets Glossip's execution for April 18, 2023. So, and in this, because the reversal is based on allegations that if the jury had known these things about Sneed, they would have never convicted Richard Glossip. I want to go through all of the statements that the jury heard from sources other than Justin Sneed, because it is these statements out of Richard Glossip's mouth that convicted him, not Justin Sneed's. Justin Sneed's testimony connected 2 or 3 dots in the case. But it's the other statements that he made to other people that led the jury to conclude that he ordered the murder and was involved in the murder, not
Right.
just an accessory after the fact or whatever other BS claims his advocates have made for him in the media. So, on January 6, 1997, Glossip asked Billy Hooper to pay the cable bill with her own money so Barry Van Treese wouldn't find out that it had been disconnected. So the cable to the motel had not been paid, the cable company had shut it off, and Glossip needed to get it turned back on before Barry Van Treese arrived that day, because he knows he's coming. So
And he knows he's going to get busted.
Yeah, I mean, he knows, he knew what he was doing, and he probably knew he was going to get caught eventually. He just didn't realize he'd gotten caught by then. But, that's later on. On January 7th, 1997 at 8:30 a.m., Glossip tells Billy Hooper Barry got up early and went to breakfast and was going to get some materials. They were going to start working on the motel that day. He also told Billy Hooper Barry rented room 102 to two drunks who broke the window. He told her not to put it on the housekeeping report. He and Sneed would clean it themselves. 2:30 p.m. to 3 p.m., Billy Hooper got a call from the Ryoki Credit Union about finding Barry's car in their parking lot. Cliff Everhart, who, yes, he's a character. Yes, he's a shady character in this whole drama. But his statements, he said that Glossip appeared to comply with a search of all rooms. Glossip helped search the area around the motel with Everhart and Deanna. Glossip had a liquidation sale and sold everything he owned. Glossip said he was moving on. Glossip told Everhart that Barry arrived at about 2:30 or 3 a.m. from Tulsa and went to bed. He said he saw Barry at 7 a.m. when he left the motel to get supplies. He told Everhart that he rented room 102 to a couple of drunk cowboys who broke the window. And then also in the presence of Tim Brown, he told Everhart that people upstairs could have been responsible for Barry's disappearance because he said they disappeared without checking out. Donna Van Treese, on January 7th, 1997, between 3:30 and 4:30 p.m., Glossip told Donna he last saw Barry between 7 and 7:30 a.m. He said Barry told Glossip he was going to buy supplies for the motel and would be back later. He told Donna Van Treese that Barry looked and sounded fine, and he promised to check all the rooms and around the motel property to search for Barry. Kayla Pursley, during the morning of January 7th, he told her that two drunks got into a fight and threw a footstool through the window in room 102, and he said Sneed and he had thrown them out. He told Kayla that someone got cut cleaning up the glass because apparently there was blood visible, which was probably Barry's. And then he said he told Kayla Pursley that she saw one of the drunk cowboys at the Sinclair station. So he's trying to influence her future statements by telling her, you saw him. You saw
Right.
one of them.
Exactly.
On Jackie Williams, he told her on January 7th, don't clean the downstairs room. I'll clean them with Sneed. And there's been, in recent years, they've tried to say, well, Sneed told people this. And, well, if Sneed told Jackie Williams that not to clean the downstairs rooms, why would she say, she wouldn't be saying, I'll clean him with Sneed. She would be saying, he said, I'll clean him with Glossip.
Right.
But January 7th, 1997, Officer Tim Brown Glossip told Brown, and I think this is similar to what he told Everhart. He last saw Barry walking through the motel parking lot at 7 a.m. He told Brown Sneed said a couple of drunks got into a fight and broke the window, and he had to take them off the property. He saw Barry after the window was broken. He thought he saw Barry in the morning, but he wasn't sure. He told Brown on January 8th at the station, everything started getting confused, and the last time he remembered seeing Barry was 8 p.m. the night before when he picked up payroll money right before he left for Tulsa. He denied saying he saw Barry at 7 a.m., and then he also again said that people upstairs could have been responsible for Barry's disappearance because he said they disappeared without ever checking out. William Bender, he told him on January 8th that Barry was beaten to a bloody pulp, that they found him cold as ice, dead as a doornail, that Glossip knew who did it, that Glossip was in fear for his life, that Bender needed to get out of the Tulsa hotel because it's going to be brought down, that he'd sold his personal property, and that he was moving on.
Why would Glossip be in fear for his life?
He wasn't. He was just telling Bender. Stuff. I mean, like under Glossip's watch, that motel had become an absolute shithole. And they had drug dealers. I mean, his drug dealing brother was staying in a room selling drugs out of that room. It wasn't it was the kind of place if you checked in because you were driving through and you needed to stop for the night, you probably would have taken one look at a room and left
Yeah, it
and said, "I
wasn't
can't stay here."
right. It wasn't us. It wasn't even probably a Motel 6. It was a pretty rough.
Yeah, no. And recent years, Reed Smith and Don Knight and all the advocates for Glossip, I want to call them something else so badly, but I won't. Um, they try to say, well, that was Barry's fault. He wouldn't spend the money. It's like, but Glossip took money saying he was going to do these things and he never did them.
They never fixed it. Yeah.
You know, and I mean, there were the problems with the motel were really awful. I mean, there were rooms that couldn't even be rented anymore because they were destroyed.
Yeah, and Barry has a lot of hotels and other jobs, so he's really
Correct.
depending on Glossip to
Correct.
really run the place. He
He
gives them
was,
the money,
and
but he's running it.
especially during the later part of 1994, Barry had his mother was ill and she died. He was ill, I believe. So he was really he needed a good steward, and Glossop was not a good steward because Glossop
Right.
was just out for what he could get for himself. And we've seen
Right.
that time and time again throughout his incarceration of, him just using Leah, his first wife, Lee. I don't know if she's Leah or Lee, whatever. And I mean, I know of two other women that he used who felt bad for him and thought he was innocent. And they contacted him and he immediately started trying to extort money from them. And when they wouldn't give him money, he would make them feel guilty and
Right.
berate them and mistreat them and abuse them
Well, and it's
verbally.
all one of these things. It doesn't mean he's guilty, but he's not exactly a really kind of a good guy.
Mm-mm.
He has a history of kind of being a jackass.
Yeah. And he was just lucky enough never to get caught
Right.
until now. January 8th, he's questioned by detectives Bemo and Cook. Bemo introduces himself and Cook, giving no indication that either of them knows Glossip, because later on, Glossip's tried to claim that Bemo and Cook were somehow misjudging him. Um, and he claimed that he had a history with Bemo because in this initial encounter, he doesn't mention an alleged report against Bemo or give any indication that he knows Bemo, and Bemo doesn't know Glossip, and Glossip doesn't know Bemo. But later on, Glossip says, "Well, no, I reported problems at the motel before, and Bemo or at another motel I worked at, because consequently, he worked in another motel that there was thieving going on."
Right.
Before he came to the Best Budget Inn. Glossip had run the Grand Continental for 4 years. He ran the Best Budget for 2 years. He was administered his Miranda warnings. He acknowledged that he called Donna looking for Barry on January 6th because Billy was waiting on her check and refused to leave until she was paid. He said the last time he saw Barry was when he left for Tulsa at 7:50 p.m. He knew the time because Deanna directed him to look at the clock. At 5 a.m., he and Deanna were getting ready to go to sleep when they heard tapping on their door, then along the wall. Glossip got up and found Sneed, whom he referred to as Justin Taylor, at the door. So he's not using Sneed's real name, he's using Sneed's alias when he talks about him to police. Glossip claimed Sneed told him 2 drunks broke the window in room 102 and that Sneed ran them off from the property, which contradicts what he had told other people about him running them off. Glossip noticed a knot on Sneed's head that Sneed told him happened when he dozed off in the shower and hit his head on the soap dish. Sneed woke him up at 8 a.m. or 8:30 to help put plexiglass up on the outside of the window to room 102. Glossip and Deanna went back to bed, and he told Billy to wake him up at noon. Glossip and Deanna got up around 1 p.m. when Billy woke them up and went to get glasses, buy Deanna a ring, and get construction material supplies at Walmart. Among those was air fresheners in plastic bags. He picked up blinds, air fresheners, and was getting paint when Deanna was paged by Billy, which that was probably to clean up the crime scene in room 102 after they got rid of Barry's body. Billy told him Barry was dead, told him his car had been found at Weoki Credit Union. Glossip and Deanna bought the air fresheners and returned to the motel. He went with Cliff and Deanna to search dumpsters around the motel. He and Sneed disappeared right after. He said Sneed disappeared right after he got back from Walmart, probably because Glossip went up and told him, "You better run." Glossip said he knew something was wrong when he saw Sneed's head and they found Barry's car. Glossip insists he had nothing to do with the murder because he was in bed with his girlfriend when Barry was killed. Glossip said he had a feeling Sneed did it, said he didn't see Sneed doing it, said Barry picked up 9 days of deposits of about $450 per day. He said Barry collected $3,600 to $4,000 in cash deposits. That Glossip admitted he saw Sneed when they got back from Walmart and yelled to him, but claims he had to go inside and talk to Cliff Everhart. He told BMO about an alleged complaint against the owner of the Grand Continental related to Glossip's name being on accounts and the owner forging his name to checks. Glossip does not refer to any investigation that was supposed to have been conducted by BMO, nor a complaint he made against BMO. Glossip said the Grand Continental shut down and Everhart brought him to Van Treese, who hired him to manage the best budget. Glossip said he makes a good living and that he and Deanna go out and do stupid stuff like buy clothes and she collects perfume. That's all they do. Glossip said Sneed stole pennies from Big John, a longtime tenant. Big John had a collection of pennies, and during his vacation, Sneed asked Glossip for penny rolls and exchanged pennies for quarters for the vending machines. Glossip said Sneed had master keys to all the rooms. Glossip said Barry stayed in room 108 the last time he visited the motel. Glossip said Barry stayed in room 255 and room 229 on prior visits. Glossip said there are water beds in rooms 101, 102, and 125. Glossip said the stereo in room 102 was a piece of shit that came out of the laundry. Said the same stereo was in room 125. Glossip repeated the claims about Sneed having master keys to all the rooms, implying that he shouldn't have had them. Also said Sneed had deadbolt keys to all the rooms. Glossip said Barry did not park out front when he came back from Tulsa that morning. Barry said he had a hunch Sneed did it, but didn't know for. Glossip said he had a hunch Sneed did it, but didn't know for sure. Claimed he told Tim Brown Justin Taylor when Brown asked for Sneed's name. Glossip admitted that he didn't tell Brown about Sneed's eye. Then they brought Brown in to kind of confront Glossip with some of the other statements he'd made. And when Glossip denied it, ever making the statements Brown was recounting, Glossip says, "I'm not calling you a liar, Tim. Maybe I didn't hear you. I know it's pointing in my direction." Glossip said after they found the car, "I knew Justin was involved, but claimed he didn't know Barry was actually dead." Glossip claimed he made $750 per month from his vending machines. Glossip insisted that he had plenty of money and didn't need Barry's money. Glossip claimed he told Brown, "I thought I saw Barry." That's the only person he told that to, which is untrue because he told Billy and Cliff Everhart the same things. Claimed he saw a man with gray hair walking to Sinclair's. Claimed he never saw Barry and never saw his car parked out front. He claimed that Kayla Pursley's stories were changing, which is rich. He said he claimed that Kayla called a cab for a man in 237 and her times were off. Claimed he never told anyone room 102 was rented to two cowboys. Claimed that room 102 wasn't supposed to be rented. Claimed there was no card for room 102. Believed Justin was watching and laughing at him. Said Justin intended to fall on me. That's why he left. Claimed he didn't know Barry was dead. Said Sneed had nowhere to go. When the Detective accused Glossip of double talking everything. Glossip said, nobody asked me a direct question. Glossip said I shouldn't have to be dealing with this. He claimed Justin and West talked about killing people. He claimed Justin and West were skinheads. He claimed Justin and West were drug dealers. He admitted that he and Deanna bought Justin food and paid for Justin's meals when Justin picked food up for them. He admitted Justin had no money. Glossip said he bought Justin cigarettes all the time, said Justin didn't trust him enough to confide in him, and claimed to have caught Billy renting rooms off the books and taking the money. And this is what they believe Glossip was doing. Which, I mean, I don't think Barry would want to be renting a room to Bobby Glossip, Glossip's drug dealing brother. And I wonder, was Bobby even paying for that room? Or was the money Bobby was paying going into Glossip's pocket or in the till? Now, after he's picked up on the 9th, his statements kind of change. First of all, he admits lying about everything he said on the 8th. And he says, I know I should never have lied. Glossip said Barry collected money for 9 days at $400 to $500 per day, which in his estimates means Barry had $4,000 to $5,000, which is more than he said the day before. He admits that he knew something was wrong. He admits that Justin told him he killed Barry. Glossip said Justin mentioned a belt, but he couldn't elaborate. He claimed Justin was mumbling and he couldn't understand a lot of what he said. He said Justin told him he thought Barry was going to throw him out into the street. Glossip said he didn't believe that was the only thing. Glossip said Justin was mumbling and that he was scared. Glossip was scared. Glossip couldn't believe Justin actually did it. Glossip told Justin to clean up the glass because I didn't want to touch nothing. Which, if you're innocent, why would you not want to touch anything? And Glossip said, I didn't want my prints on a damn thing.
Exactly.
Glossip said he told Justin to buy plexiglass for the outside of the window. He admitted to helping Justin put the plexiglass up, which I think witnesses had told police that had happened. Glossip said the blinds were down in room 102 and it looked like something was on the inside of the window, which was the shower curtain, which Sneed and Glossip put up in the early morning hours. Glossip went back to bed and told Billy to wake him at noon. He claimed Deanna told him not to say anything. So, Glossip's one of those winners that it's never his fault. If he does something wrong, he's always acting on the advice of someone else. So Deanna's the one that told him not to come clean about Justin to the cops when the cops questioned him. Claimed he knew Everhard had something to do with this, so he's trying to throw Cliff Everhard under the bus. He admitted that he didn't tell the truth because he didn't want to lose Deanna. He admitted that he was protecting himself. He said Barry never told him he had to get money because other people were saying, Barry said he's going to come up with the money that he stole or I'm going to call the cops. He said he and Barry were going to fix up the rooms at the motel. He claimed Barry told his brother Ken that Glossip was a good guy. He said a woman named Carol, who was a Van Treese family member, told him to get an attorney. And he said that during his interview with David McKenzie didn't want to hear the whole truth because he didn't want to know. Glossip was arrested on January 9th, 1997 by the Oklahoma City PD. Sneed was arrested on the 14th of January at his roofing employer's home by Oklahoma City PD. On January 15th, 1997, charges were filed against Sneed and Glossip of murder in the first degree under docket number CF-1997-244. And then on the 15th, they also filed an information against Glossip in a separate case, which is CF 1997-256, for accessory after the fact. Then an amended information was filed on January 23rd, 1997, which added Glossip as defendant B to the 244 information. A bill of particulars was filed on April 23rd, 1997, and that was murder for remuneration or employed another to commit murder and continuing threat. That was to support seeking the death penalty. Now, I'm going to go through because, again, the evidence against Glossip has been ignored in favor of a speculative fantasy story about the case against Glossip, that it all hinged on Justin Sneed, which has never been true. A juror from the second trial interviewed in 2012 or 2015 said it was Glossip's words that convicted him, not Justin Sneed's. So I'm going to go through the OCCA's evidentiary findings from Glossip's direct appeal. And those were made on in their opinion on April 13th, 2007. They said there is both direct and circumstantial evidence supporting the conviction. Money in Glossip's possession at arrest. No evidence that Sneed had independent knowledge of the money under Barry's car seat. The condition of the motel at the time of Barry's death was deplorable. Glossip was the person responsible for the day-to-day operations of the motel, and he knew he would be blamed for the motel's condition. Glossip concealed Barry's body from investigators all day long, and he lied about the broken window. Glossip admitting knowing that Sneed killed Barry in room 102. Glossip knew about the broken window, but never told anyone that he thought Sneed was involved in the murder until after he was taken into custody after Barry's body was found. Glossip intentionally lied by telling people that Barry had left early that morning to get supplies when he knew that Barry had been killed in the early hours of the morning before his claimed sightings. Glossip's stories about when he last saw Barry were inconsistent. He said that he last saw him at 7 a.m. Later he said he saw him at 4:30 a.m. Then he said he saw him at 8 p.m. the night before. Glossip later denied making these statements regarding the times he last saw Barry. Glossip intentionally steered everyone away from room 102. Glossip told people that Barry stayed in room 108 the night before. Glossip lied about how the window was broken, telling a number of people that two drunken cowboys broke the window. Glossip tried to implicate a person who was observed at the nearby Sinclair station as one of those cowboys. Glossip told Everhart that he would search the rooms for Barry, and then he told Sneed to search the rooms for Barry. At the time Glossip searched areas around the motel with Everhart and Deanne Wood, Glossip knew Barry had been murdered in room 102 by Sneed. Glossip admitted that he actively concealed Barry's body. Glossip said he lied about Sneed telling him about killing Barry not to protect Sneed, but because he felt like he was involved in it. None of Glossip's fingerprints were found in room 102, and because he's the manager of the motel and would have gone in there to fix things or to clean, you should have found at least a single fingerprint somewhere.
Right. Exactly.
And Sneed had no motive to kill Barry other than the offer of money from Glossip. And now I'm just going to kind of summarize the state and federal post-conviction. I'm not going to go into...
And I think you probably went into this on earlier episodes, but Sneed didn't really have a violent history. Am I misremembering?
No.
I mean, he's not a Boy Scout, but...
Right. Now, the problem is that in recent years, they have beating people and robbing people and threatening people, and that this was an attempt to rob Barry Van Treese that went bad. But contemporaneously, at the time of the murder and at the time of Glossip's trial, none of those things ever came out, and Glossip certainly would have known them.
Right.
If that's who Justin Sneed really was, Glossip would have been, the one person to know about it because Sneed was close to him. And he can deny that, and his attorneys can try and rewrite history about that. But, when you look at the contemporaneous statements, everybody says Sneed kind of looked up to and stuck to Glossip like glue.
Right. And he just, yeah, I mean, again, doesn't mean he's innocent because there's always a first time, but he doesn't seem like the type of guy that it would have just gone and randomly murdered somebody
No,
for
no.
money.
And again, he had no motive. He was there at Glossip's pleasure more than anything else.
Right.
And he was there with a free room because Glossip had convinced him to leave the roofing job that he had and to stay at the motel and be kind of a maintenance man who would get his room for free. And this was Glossop's way, probably, of taking money that was allocated for hiring a maintenance person to put that into his own pocket.
Right.
Because he's not paying, he's getting a room,
Right.
but he's not paying him a salary.
Right.
So, and that may have been acceptable to Barry Van Treese. I don't know. He's not here to give us his side of the story about all this.
Right.
But Glossip's there day to day, not Barry Van Treese.
Right.
So you can spin the narrative as much as you want, but in the end, if there's a problem at the motel, crime, condition, whatever, drugs, low lives, it's not Barry Van Treese's fault.
Right. Yeah. Because at the end of the day, Glossip is the de facto
Mhm.
effective owner of the hotel, even though he doesn't actually own it. He's
Well,
running it day to day.
he's not. It's not de facto owner. He's the person in charge.
Yeah, he's in charge of it.
So, so Glossip state post conviction, he has had 1, 2, 3, 4, 5. release. His relief, request for hearing and discovery, and stay of execution were all denied. 2022, relief, request for hearing and discovery denied. Second relief, request for hearing and discovery, all denied again. This was the second writ in 2022. And then finally, on his fifth writ, relief, request for hearing and discovery were denied in 2023. And that was the appeal to the U.S. Supreme Court that we will talk about later. Federal habeas, he has his petition for writ of habeas corpus was denied in 2010. The 10th Circuit affirmed that in 2013. He filed an amended writ pro se in 2015, which was denied on January 8, 2015 for lack of jurisdiction. He has filed multiple writs at the U.S. Supreme Court. His first one for review after direct appeal was denied on January 28, 2008. His second after denial of his federal habeas claims was denied on May 5th, 2014. So the petition for writ of certiorari was denied. On June 29, 2015, the use of midazolam in executions was affirmed by the U.S. Supreme Court, which was another writ that he had filed with other inmates challenging Oklahoma's execution protocol. On September 30th, 2015, his writ denying his 2015 state writ, state post-conviction, was denied. And then on March 10th, 2025, the writ that he filed challenging the denial of his two 2022 writs was declared moot. On May 4th, 2023, he filed his 6th writ to the U.S. Supreme Court, petition for writ of certiorari, from the denial of his 2023 state post-conviction claim. The questions presented were whether the state suppression of key prosecution witnesses' admission he was under the care of a psychiatrist and failure to correct that witness's false testimony about the care and related diagnosis violated due process of law under Brady and Napiew, whether the entirety of the suppressed evidence must be considered when assessing the materiality of Brady and Nat Pugh claims, and that was under basically Kyles versus Whitley, which we talked about, and whether due process of law requires reversal where a capital conviction is so infected with errors that the state no longer seeks to defend it. And that is basically the problem. Because Gentner Drummond, for whatever reason, decided to stop advocating for the victims in this case, the Van Treese family and Barry Van Treese, and decided to advocate for his killer. And so he, based on speculative, fictional narrative created by Reed Smith and Don Knight, and then championed by Rex Duncan at the direction of Reed Smith and Don Knight, he said, oh, wait a second, look, we found these notes and the prosecution knew about this. And so then, they should have done that, which isn't even true. Nobody ever talked to the prosecutors to say, here's this note. What were you, where, how did this come about? When did this come about? Because in reality, the note that they relied on was a conversation with Justin Sneed about an interview he had with the defense investigators. So all this information in that note was given to the defense investigators. And stay up on my soapbox a little bit longer. Brady does not absolve defense attorneys of their duty to investigate. So if you have a co-defendant testifying against your client who says, who in a competency report says they're on lithium, you don't just sit back and wait for the prosecution to tell you who prescribed that and why. You seek that information out yourselves.
Right.
And there are hoops you're going to have to jump through, because you're going to have to go to the court and you're going to have to say, okay, he's on lithium. We need to know why. We need a court order or subpoena for these records. But it can be done. And they never did that. And they never did it. And Don Knight has never done it. Because I think he doesn't want what the actual records say, because he wants to be able to make it up as he goes along. And that's basically what this was. This is a make it up as we go along. And it's also based on notes that I'm not sure they were even really entitled to in the post-conviction thing. Because, again, these are notes from an interview with Sneed. So I think that the Gentner Drummond turned over work product that he didn't need to turn over, that he wasn't duty bound to turn over. All right, so I'm get off my soapbox now. On May 5th, 2023, Glossip's application for stay of execution presented to Justice Kavanaugh and referred to the court is granted pending the disposition of the petitions for writ of certiorari numbers 226500 and 227466. Should both petitions be denied, the stay shall terminate automatically. In the event either is granted, the stay shall terminate upon the issuance of the mandate of this court. Justice Gorsuch took no part in the consideration or decision of this application. An order was entered on January 22nd, 2024, granting motion proceed in form of pauperis and petition for writ of certiorari In addition to the questions presented, the parties are directed to brief and argue the following question: whether the Oklahoma Court of Criminal Appeals holding that the Oklahoma Post-Conviction Procedure Act precluded post-conviction relief is an adequate and independent state law ground for the judgment. Again, Justice Gorsuch took no part in the consideration or decision because he was formerly on the 10th Circuit Court of Appeals. An order was also entered on January 26, 2024, inviting Christopher G. Michelle of Washington, D.C. To brief and argue the case as amicus curiae in support of the judgment below. And I saw on Twitter and other social media, Glossip advocates were incensed at this because, again, they felt that this should be one-sided. There should be no voice for Barry Van Treese in this process. And I saw other media outlets lying and saying that the Van Treese family supported a new trial, which has never been true. On April 23rd, 2024, the petitioner and respondent briefs were filed by Glossip and the Oklahoma AG. Amicus briefs in support of Glossip were also filed on April 30th by Innocence Project, American Civil Liberties Union, McDougal et al., the Clown Posse, as we call them, Kenneth T. Cuccinelli, a former AG of the Commonwealth of Virginia, the District of Columbia, and several other states, which actually were filing in support of neither party. I think they were just getting their they were filing insofar as the state post-conviction procedures portion of the case went. Federal court scholars, Michael Cassidy, National Association of Criminal Defense Lawyers, former members of the Oklahoma Death Penalty Review Commission, and current and former state and federal prosecutors. And then amicus briefs were filed on July 8th, 2024 on behalf of Mr. Michelle, who was in support of the judgment below. And then on the 15th, also in support of judgment below were briefs filed by the state of Texas, the state of Utah, victim family members Derek Van Treese et al., and the Criminal Justice Legal Foundation. On July 26th, the case was set for oral argument on October 9th. On August 19th, 2024, a joint motion of petitioner and respondent for divided argument is granted. The motion of Derek Van Treese et al. For leave to participate in oral argument as amici and for divided argument was denied, so the Supreme Court would not allow the victim's family to argue in support of the judgment below, which I think is inequitable. They had two voices arguing against, Glossip and the AG. So why not allow the attorney you appointed and the victim's family to argue in support of the judgment below? But they didn't. On February 25th, 2025, the Supreme Court issued its opinion. Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts, Justices Kagan, Kavanaugh, and Jackson joined, and in which Justice Barrett joined as Part 2. Justice Barrett filed an opinion concurring in part and dissenting in part. Justice Thomas filed a dissenting opinion, in which Justice Alito joined, and in which Justice Barrett joined as to parts 4A-1 and 4A-2 and 4A-3. Again, Gorsuch took no part. The court held this court has jurisdiction to review the OCCA's judgment. The independent and adequate state ground doctrine precludes the court from considering a federal question if the state court's decision rests on an independent and adequate state law ground. OCCA's application of the PCPA was not such a ground because the OCCA's decision to apply the PCPA depended on its antecedent rejection of the Attorney General's confession of a NAPU error, which was based solely on federal law. The OCCA held that the confession could not overcome the PA's limitations because it lacked a basis in law or fact, specifically finding no NAPU error. Oklahoma precedent confirms that the OCCA normally rejects an attorney general's confession of error only after finding it unsupported by law in the record. By making the application of the PCPA contingent on its determination that the attorney general's confession of federal constitutional error was baseless, the OCCA made the procedural bar dependent on an antecedent ruling on federal law. To the extent that the OCCA's reasoning on this point is insufficiently clear from the face of the opinion, the court presumes reliance on federal law under Michigan versus Long. The prosecution violated its constitutional obligation to correct false testimony, which, again, they didn't really have a good factual record before them. Under NAPU, a conviction obtained through the knowing use of false evidence violates the 14th Amendment's due process clause. To establish a NAPU violation, a defendant must show that the prosecution knowingly solicited or allowed false testimony to go uncorrected. If a violation is established, a new trial is warranted if the false testimony could in any reasonable likelihood have affected the jury's judgment, meaning ordinarily that the prosecution must establish harmlessness beyond a reasonable doubt. Here, Oklahoma's Attorney General joins Glossip in asserting a NAPU error, conceding that Snead's testimony about his lithium prescription was false and that the prosecution knowingly failed to correct it. The record supports that confession of error, which it doesn't, really. Evidence showed that Snead was prescribed lithium to treat bipolar disorder, not after asking for cold medicine as he claimed at trial. That's not true. They've never produced Snead's medical records. They've never obtained Snead's medical records. The evidence likewise establishes that the prosecution knew Snead's testimony was false. The prosecution almost certainly had access to Snead's medical file through Snead's competency evaluation, which was not performed at their request, was performed at the request of his attorney in his criminal case, not Glossip's. And that was performed prior to Glossip's first trial, not in between the first and second trial, or prior to the second trial, immediately prior to the second trial. And Smotherman's notes show she had a pretrial conversation with Snead at which he mentioned lithium and Dr. Trumpet. The straightforward inference is that Smotherman was aware before trial that Snead received his lithium prescription from Dr. Tromka, a psychiatrist and the sole medical professional at the Oklahoma County Jail authorized to prescribe lithium. Again, this was not really established on the record. This was basically speculative argument made by Glossip. And again, I stand by the fact that if this is recounting a meeting with defense investigators, they had this information. They had Dr. Trumpet, and they deal ODIC, I think is what the agency is called. That's the Indigent Defense in Oklahoma. They deal with people in the jail all the time. They know people at the jail.
Right.
It's not like they're strangers to the jail.
Right.
Anyway, because Snead's testimony was the only direct evidence of Glossip's guilt, which is untrue, because we have all these statements Glossip made to people that show that he made when he knew Barry was dead about having seen Barry. And we have his statements to police about what he knew and when he knew it. Because Snead's testimony was the only direct evidence of Glossip's guilt, the jury's assessment of Snead's credibility was material and necessarily determinative. Correcting Snead's lie would have undermined his credibility and revealed his willingness to lie under oath. The false testimony also bore on Glossip's guilt because evidence of Snead's bipolar disorder, which could trigger impulsive violence when combined with his drug use, would have contradicted the prosecution's portrayal of Snead as harmless without Glossip's influence. And again, This is all based on speculative argument having been being made by Don Knight since 2015. He's never proven any of this. He's never met the bar of clear and convincing evidence of this.
Right.
He's just rewriting history about who Snead was in 1997. Hence, there's a reasonable likelihood that correcting Snead's testimony would have affected the judgment of the jury. Again, the judgment of the jury was based on Glossip's statements after the murder to police and others, not on Snead's testimony about the murder. Additional prosecutorial misconduct, such as violating the rule of sequestration, destroying evidence, and withholding witness statements, further undermines confidence in the verdict. Again, these are all things that Glossip has never proven, but they were presented as proven by the state in its, quote, confession of error. Consequently, the prosecution's failed to correct Snead's false testimony entitles Glossip to a new trial under NAPU. The OCCA's contrary holding rests on a mistaken interpretation of NAPU. The OCCA held that there was no violation because the defense was aware or should have been aware that Snead was taking lithium. But Snead's false testimony concerned the reasons for his prescription, not merely the fact that he had taken lithium. Moreover, the Due Process Clause imposes a duty to correct false testimony on the state, not the defense. The OCCA is holding that Snead is likely in denial of his mental health disorders is beside the point. What matters is that the testimony was false and the prosecutor knowingly allowed it to stand. And again, they've never presented any evidence that the state knew what Snead's medical treatment and or diagnoses ever were. They're saying they had access to his medical file, but that's speculative. And they certainly have never said, we've been through their records and there are Snead's medical records right there. And, privacy, the state doesn't, in fact, I don't think the state could produce records to Glossip absent a subpoena or order from the court to do so.
Yeah, HIPAA is very strict.
Because that would be a big violation.
Yeah, it'd be a big HIPAA violation.
Because I know, we do it. We have to do it like if we're going to have them, we're going to have an IME or something, but that's because they put their medical condition at issue.
Isn't that a little bit on the defense, though? I mean, anytime you have that, isn't that just like a basic question you would ask if you're interviewing Snead? I mean, that seems like that would be on the defense to just.
It does, but again, here they're trying to say what they're basically doing is saying this proves they knew it was false, and it doesn't.
Right.
And right, as I've said, neither Brady nor NAPU or any other thing. I mean, none of those absolve the defense of their responsibility to investigate.
Exactly. They're almost blaming because they didn't do a good job. They're saying, "Oh, we missed something." So.
Right. Well, it's just that's like Monday morning quarterbacking.
Right.
And the defense could have impeached him because this is during direct questioning that these alleged lies are told. So the defense could have gotten up and said, well, you weren't prescribed for a cold. You were prescribed because you had bipolar disorder. Here's the competency evaluation. They had that information. So it's just, I don't know. This is one of those travesties of the U.S. Supreme Court that because it's in favor of the murderer, it's going to be recognized for what it is.
Yeah, and I'm kind of surprised. I mean, I don't know off the top of my head, but I mean, it's not super common that SCOTUS intervenes in criminal cases. Am I right? I mean, it happens some, but
it happens some, but and in this case, and I I sometimes don't understand Kavanaugh because he's really been siding with the liberals a little bit too much for my taste. And in this case, again, the evidentiary record, none of these things that they cite as fact are proven fact. They're
Right.
argument, they're conclusory allegations. There are conclusory allegations that have been rejected by the Court of Criminal Appeals, the Oklahoma Court of Criminal Appeals, on 3 other occasions. And yet they're citing him as proven fact. So I'm going to skip over some of this other faulty materiality findings or holdings or whatever it is. But basically, they say because the Attorney General's confession of error is supported by ample evidence, questionable. The court declines to remand the case for further evidentiary proceedings. When the court has jurisdiction, a new trial is the appropriate remedy for a violation of NAPU. So they reversed and remanded. And that is an unusual step for them to take. But it's not one they've never taken. I mean, Curtis Flowers in Mississippi.
Yeah, it's not unprecedented. It's just not super common.
And if my reading of their opinion in that case is correct, they actually, instead of focusing on the trial the last trial at which he was convicted, they aggregated all the trials and found basically a jury selection violation across all the trials, not just the last trial. Even though his convictions in those other trials had been reversed for other reasons, or maybe even for, failures in jury selection. I don't know, but yeah, it was kind of disturbing. Okay, so now we go on to Justice Barrett's concurring in part and dissenting in part. And she states, while I agree with much of the court's analysis, I would not order the Oklahoma Court of Criminal Appeals to set aside Richard Glossip's conviction. The OCCA did not make factual findings on the most important questions, and the record is open to multiple plausible interpretations. Consistent with our ordinary practice, the court should have corrected the OCCA's misstatement of NAPU versus Illinois and remanded this case for further proceedings. Instead, the court has drawn its own conclusions about what the record shows, thereby exceeding its role. I part ways with the court on what comes next. In exercising our appellate function, it is not our role to find facts. Instead, we review the factual findings of lower courts subject to a deferential standard of appellate review. This practice makes good sense. This court is well equipped to answer questions of federal law. It is ill equipped either to determine the credibility of witnesses or to master voluminous trial records. Other actors in our judicial system, including where appropriate state courts like the OCCA, better serve these functions, as our standard of review reflects. In this case, however, the court has chosen to function as the initial fact finder. To establish a violation of NAPU, Glossip must show notes taken by Smotherman, an affidavit from Dr. Tromka, and a medical information sheet. According to the court, these documents clearly demonstrate that Snead lied when he said that he did not know why he had been given lithium and that he had never seen a psychiatrist, and Smotherman knew that both of these statements were lies. See ante 17 to 19 at 26. Thus, the court concludes there is no need for the OCCA to make its own factual findings. I respectfully disagree. Smotherman's notes taken during a jailhouse interview of Snead consist of the words "on lithium?" and Dr. Trumpet?. These notes are hardly clear, and there are competing explanations of what they mean. Glossip, the Oklahoma Attorney General, and the court argued that they demonstrate Smotherman's knowledge that Snead had lied about Dr. Tromka's prescribing him lithium for bipolar disorder. The Van Treese amicus brief and Justice Thomas contend that the notes instead reflect Snead's account of a conversation with Glossip's lawyers, who had asked Snead whether he had received lithium from a Dr. Trumpet. And, there are other possibilities too. For instance, perhaps Smotherman was confused by references to Dr. Trumpet and lithium, but never investigated the issue further. Neither Dr. Tromka's affidavit nor the attached medical information sheet, nor any of the other record evidence discussed by the court forecloses any of these possibilities. When the record is susceptible to multiple plausible inferences, this court should not be in the business of choosing between them. It should have corrected the OCCA's misstatement of federal law and vacated the judgment, leaving next steps, including the decision whether to conduct an evidentiary hearing to the OCCA. By doing otherwise, the court has both displaced the OCCA as fact finder and potentially overridden state law constraints on the OCCA's remedial authority. Because the court has exceeded its appellate role, I respectfully dissent in part. And then Justice Thomas, with whom Justice Alito and Justice Barrett joined, wrote a dissenting opinion. Richard Glossip, a convicted murderer, twice sentenced to death by Oklahoma juries, challenges the denial of his fifth application for state post-conviction relief. Although Glossip won the support of Oklahoma's new Attorney General, he failed to persuade either body with authority to grant him relief. The Oklahoma Court of Criminal Appeals denied Glossip's application as both procedurally deficient and non-meritorious, and Oklahoma's Pardon and Parole Board denied clemency. Because this court lacks the power to override these denials, Cox federal jurisdiction by misreading the decision below. On the merits, it finds a due process violation based on patently immaterial testimony about a witness's medical condition. And for the remedy, it orders a new trial in violation of black letter law on the court's power to review state court judgments. I respectfully dissent. Justice Thomas, I would recommend anybody reading just his dissent on this one. He's really a master at writing dissents.
Yeah.
I look forward to some of these cases. I look forward to Thomas's dissent.
Yeah, I think he's probably hands in a way the smartest and most thoughtful justice.
Mm-hmm. He goes on to say, after having bent the law at every turn to grant relief to Glossip, the court suddenly retreats to faux formalism when dealing with the victim's family. The court concludes that it need not honor the family's right to be heard because the family did not request an evidentiary hearing earlier in the proceedings. But the family had no need to do so, since Glossip had conceded that a hearing is necessary for his claim to rise above the level of speculation. And before this court, the Van Treese family has vigorously asserted its interests. The family filed the only brief opposing certiorari in this case. It filed a merits brief highlighting critical evidence that the parties sought to sweep under the rug. And it filed a motion to participate in oral argument, which the court denied. The majority's assertion that the family has sat on its rights is groundless, nor is there any reason to believe that Oklahoma victims' right to be heard in any proceeding contains an implicit exception for post-conviction hearings. Finally, even if the family had no formal right to be heard, any reasonable fact finder plainly could consider the account of the evidence that the family has brought to light, making the majority's procedural objections beside the point. Make no mistake, the majority is choosing to cast aside the family's interests. I would not. Finally, he says the court's decision distorts our jurisdiction, imagines a constitutional violation where none occurred, and abandons basic principles governing the disposition of state court appeals. I respectfully dissent. Now, on the 25th or the 26th, the Van Treese family released statements. I think they released one through Paul Cassell, who represented the U.S. Supreme Court, a well-known and well-respected victims advocate, and but Derek Van Treese also may have given direct statements as well. Um, in the statements, the family remains confident that when the new trial is held, the jury will return the same verdict as in the first two trials, guilty of first-degree murder. Derek Van Treese, Barry's son, said in a statement to Fox News Digital, provided by his family's lawyer, Paul Cassell. Excuse me. Sorry, guys. The burning issue here is process and procedure. The U.S. Supreme Court has concluded that one small bit of impeachment evidence should have been presented at Glossip trial and is remanded for a new trial. Two juries have shown that the issue at hand isn't one of guilt or innocence. Glossip is clearly guilty of first-degree murder. For the last 10,276 days, we've been waiting for justice. The family remains confident that when that new trial is held, the jury will return the same verdict as in the first two trials, guilty of first-degree murder. As difficult as it may be to start fresh on a 28-year-old case, I hope that the Attorney General and the Oklahoma County District Attorney's Office can begin to show the perseverance that our family has shown throughout this process. We pray that they exhibit the fortitude to take politics out of the equation and process this case as it is, a death penalty case, and not take the easy road of a lesser charge. If they find themselves unable to shoulder the burden, they should recuse themselves and allow someone with the aptitude and skill necessary to prosecute this case so it can finally be laid to rest once and for all. And that is, I think, the final word. Now, nothing has happened in a little bit over a month since that decision was rendered. The mandate has not filed on the Supreme Court record, nor has the decision apparently been filed into the record at the Oklahoma Court of Criminal Appeals.
And what does that mean practically?
Well, it means it's kind of in limbo right now. Drummond and Vicky Bahana have made noise about figuring out what they're going to do, but they haven't really given an indication about what that might be. Drummond has again said he doesn't believe Glossip is guilty. Excuse me. Take that back. Rewind. He doesn't believe Glossip is innocent, but he doesn't necessarily see it as a death penalty case. He doesn't see him guilty of murder. He sees him guilty as accessory after the fact. Bahana has said it's not a case that she would have prosecuted had she been in office at the time. So we don't know. We don't know what's going to happen. So that is basically where we stand.
So now, though, basically, if they don't choose to re-prosecute, he'll be set free.
Yes.
Or retry.
More likely than not. I'm thinking what might happen is they might offer him some form of Alfred plea. And then he'll be sentenced to time served.
Yeah. Because I don't think there's a world where they retry him, unfortunately.
No.
It's
unfortunately,
just, it's too hard.
Neither one of them wants to go up against Don Knight and the Clown Posse.
Yeah. Yeah, from a political perspective, it's a no-win because, I mean, it's a reality. It stinks for victims' families, but it's just kind of like the West Memphis 3 case. At some point, so much time goes by, they have other priorities, they have more pressing current priorities, and they'll say, well, he's already spent, 25 years in prison, we're not going to waste resources retrying him after he's already gone. And it's, as we've said before, it's almost impossible to try a case
right
when so much time has gone by,
because the majority, I mean, I think all but one or two of the witnesses are dead.
Right. And it's just, yeah, it's just too hard. It's easy to defend it. All you got to do is get one person reasonable doubt, and if you don't have all the witnesses, it's impossible.
Yeah.
So, unfortunately, he is probably going to walk free.
I know, and that makes me sick. And it really does. It makes me sick. Now, hopefully, they'll offer him a plea and he will reject it. And Don Knight will have dollar signs in his eyes and get greedy. And they'll want to go to trial. And they'll have enough people still around who can recount Glossip's statements. And a lot of the bullshit about Snead, that's not going to come in. I mean, it's really not. Unless they can bring it as impeachment.
So, what do you mean about the dollar signs? I'm not fully tracking with
That
you.
he thinks that he's going to go to trial, get him acquitted, and then sue the state
And
of
then
Oklahoma
sue,
for
gotcha.
$1 bazillion. If they get greedy, they might push it to trial.
But the prosecutor still has to retry him, right? I mean, if the state decides not to try him,
hopefully the prosecutor, if they offer him a deal as the easy way out and he rejects it, hopefully the prosecutor, okay, well, we'll try you then. Now, unfortunately, though, I'm afraid they might just go with accessory after the fact because they're ignoring all the other evidence that proves that he was involved, that he covered it up. So, but we'll have to see. Right now, nothing has happened in the month since the decision. So, and you know, it would be interesting to see if maybe if they don't want to do anything, maybe the Oklahoma Court of Criminal Appeals can appoint a special prosecutor. That would be, or maybe I'm hoping that people will put enough political pressure on them to either shit or get off the pot.
yeah.
Either prosecute him for capital murder, first degree murder, whatever you want to call it, or step down and seek appointment of a special prosecutor to prosecute him. And if any Oklahoma people are listening, hi Jen. Because she's a great friend. She will listen to this. Let's see about putting pressure on them to step down, and then see about the Oklahoma Court of Criminal Appeals appointing a special prosecutor. Maybe in the name of victims' rights, take it to the Oklahoma Court of Criminal Appeals. It's been 30 days. They haven't done anything. Let's appoint a special prosecutor to get the ball rolling.
Right.
So, but I think this was the biggest mistake. I mean, it's actually just, it's sickening. When I heard it, I physically felt ill. Because I could see them reversing on NAPU and sending it back for an evidentiary hearing. But the court went further than it should have gone.
Right.
And took speculative, conclusory allegations and deemed them factual. And that's just wrong. And so that's now unfortunately, if they'd had Roberts or Kavanaugh with Barrett, Thomas, and Alito, it would have been denied. There would have been a different outcome because I think if it had been 4-4, he would have lost.
Right.
That was my understanding um, of the media articles after oral argument. And people were upset that Gorsuch isn't taking part. But Gorsuch decided prior cases
Yeah.
while on the 10th Circuit. He can't take part, you know. So, well, I think that is all we have for today. It's about all I can deal with today. I'm so sorry, people.
And probably the last time we'll talk about Richard Glossip outside of an update when he unfortunately probably does get released from prison.
And I don't know if I could even deal with that. Um, yeah, I mean, yeah, we may talk about it in an update show, but I don't know that this will be a case that I'll ever. I take, I do, I take that back. If I can speak with the members of the Van Treese family who I would love to talk to, and I would love to let them tell their story and tell us about Barry and who he really was, because Reed Smith and Don Knight have tried to paint a picture um, that is frankly disgusting of them to do that to a dead man, but he's not here to defend himself. Um, I would love that. And I would also love to talk to Mr. Cassell or any of the victims advocates who participated in the amicus brief on behalf of the Van Treese family. Then I would do another episode about Richard Glossip.
That would be very interesting
Mm-hmm.
for sure.
Yeah. All right. Well, that's our show for today. And I promise I'm going to try to make this 2-week and not 3-week intervals. I apologize. I had a firm crawfish boil last weekend. And when I got home on Saturday, I could not face this and could not work on it. And so I wouldn't have been ready for last Sunday. So I shirked my duties. And now, Kyle, let's hear about your new podcast, your additional podcast.
Well, I don't know if we're gonna see. We're just gonna try it. So
Okay.
a buddy of mine from college, we're just gonna sort of do a random discussion of what's going on in the world. It'll probably be a little pop culture, a little politics, a little just stupid observations that we see in the world because we do live in such a weird world. So yeah, we're gonna try it out and see what happens. So you know how it is. It takes a lot of time and dedication to carve out time every week to record something. But yeah, we don't really. We have a tentative title. I think we're going to call it Blackie and Sherrod, but we're going to just sort of do random observations of the world. Might be some crime, but probably more just weird pop culture, political life
Okay.
observations of kind of what we see. My buddy and I, we have some pretty funny banter, and we just kind of talk about weird stuff. We both have kind of weird senses of humor, so gonna just talk about funny things that we see in the world.
Yeah. Well, I'll tell you what. I have the Captivate, and I need to. I know I need to do better about doing the audio episodes. And I know I have a bunch that I need to upload, and I will try to get that done next Saturday without fail. Um, but I know I have people sitting there. Promises, promises. Um, but if I think I have the capability of doing more than one show, distributing more than one show from that platform. So for a while, if you guys want to do audio distribution from that platform, if I can do that, I'll be happy to help you out.
Awesome. That'd be great. Yeah, for sure.
Yeah. And there are a couple of things you need to think about, like graphics for like a title page
Right.
or
Exactly. Yep.
anything. And I can't help you there because I have no artistic talent whatsoever.
I do
Uh,
like your logo. Who did that for you? I do like the based in
Audie did
Texas.
that for me. She's
Nice.
on Facebook. She was, I think she was working with Roberta for a while, and she did that for me. And I actually, when she had some issues and real life was getting in the way, so I took one of her ones that she did and I just made it blank and started using I just put my own little title and picture in. But yeah, she did that for me.
Oh, very good.
Um, I asked my nephew to do it for me, and he um, would have liked to have been paid, which I couldn't afford to do. So I was like, "Thank you."
Yeah,
I
that's
wish I could, but I really can't. But if the show starts making money, I will. But
there
because
you
I
go.
paid for the music. I had already paid for the music.
Gotcha.
So
Yeah, there's a lot of moving parts in these
that
things.
was that was the that was the extent of my budget. And so I that was and then I went to Audie and asked her if she could do it and she did it. So and she was doing the title pages for a good part of season 1, I think.
Nice. Well, fortunately, Mrs. Evans is a pretty good graphic designer, so I will probably cash in a
Oh,
favor and see if her or some of her students would like to do something.
yeah,
So
that's that right there. See? Um,
exactly, take the free work where you can get it.
right, exactly. Or she'll take it out and trade.
Exactly.
So, she'll have a honey-do list for you,
Yes, exactly.
which is what I was referring to, not something else. All right. Well, I'm going to let you get back to your Sunday. We'll close out today, and I look forward to that. I will listen to that.
Are we doing next week or in 2 weeks on
2
Selena?
weeks.
2 weeks.
We're gonna do every 2 weeks. I really like having that week to prepare, to read and get the facts, and then I use Saturday to do my notes, and then Sunday to record. So yeah,
Got
I
it.
like having that week to prepare.
Right.
Because I would have to work every night this week and then work on my notes on Saturday to record next Sunday. And that's just I don't think I could be as detailed as I am
No,
with that
that's a lot of
timeline.
work.
So all right. So thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you'd like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 5, State of Texas versus Yolanda Saldivar. We'll talk about the 1995 murder of Selena Quintanilla Perez, an American singer songwriter who was known as the Queen of Tejano music. By the age of 23, Selena had broken barriers in the Tejano music industry, which had been until then dominated by men, even in the minds of the audiences, won a Grammy Award, and launched what would become a multi-million-dollar fashion business. In early 1995, she was about to make her crossover debut as a solo pop artist in the English language market. In February 1995, she performed at a record-breaking sold-out concert at the Houston Astrodome. On March 31st, 1995, Selena's life was taken by Yolanda Saldivar, a fan who wormed her way into Selena's circle and then took advantage of Selena's trust. Until then, have a great 2 weeks and stay safe.